All right. Ladies and gentlemen, I have a very special guest. I have Damon Wright, who is arguably one of the best e-commerce and online advertising attorneys in the industry. He works for, I just call it Gordon Rees, but Damon, tell us the entire name.
Yeah, Gordon Rees is fine. Gordon Rees, Scully, and Mansukhani.
Mansukhani, which is one of the largest corporate law firms in the nation. They have offices in all 50 states, I believe.
That's right.
And Damon has helped me significantly with negotiating contracts, with keeping my business compliant. And as many of you have seen, he and his team have written the
e-commerce retailer legal guide. It's
the legal guide. All right. Yeah, I know that you put this together a couple of years ago. It was a smaller version. This version is significantly larger, goes into great detail into the things that you as an e-commerce company need to do to protect yourselves. Right. So let's just summarize this. You're investing a lot of time, a lot of money. You're probably giving up a stable job to start something that is of your own. You want to make sure that you're protecting yourself. So Damon, tell us a little bit about yourself and what you do.
Yeah, thanks, Matt. So I enjoy helping people that I like do well and make a lot of money and sleep well at night. Yeah, so that's probably where I get my satisfaction from. I'm the head of the firm's advertising and e-commerce practice group. I've been practicing law for 27 years, and I'd say that the last 12, 13 years has been focused on online advertising and understanding the business issues that our clients face and being kind of like outside general counsel to help them in all different areas to protect their business, to help them scale. And so in our group, we've got people who are subject matter experts, and every day we're reviewing VSLs, we're reviewing checkout pages, we're applying for copyrights and trademark registrations, we're defending litigation, consumer class action litigation, we're dealing with the FTC, we are creating operating agreements, helping clients sell their companies, dealing with employment issues and privacy and trade secret issues and everything under the sun, really. And just having a really close relationship with clients. And again, what I'm really proud of is that everyone on our team, they know the law as they should, but they also understand the business issues and the realities in the industry. And we go to conferences, not just to hang out with our clients, but really to continue learning all the time, because the more we know about business, the better we're able to help. You can't just say, here's the law, client, figure it out. You have to apply the law to the facts. So the better you understand the facts, the better we are. And kind of like you, I think we've got a great bird's eye view because we have a couple hundred clients and we are learning every day about what's coming down the pike and how to avoid it and problem solve in a way that what we do for this client can help this other client, not sharing client information, but just the strategies and such. So it's a lot of fun.
Well, and you hit early on when you were explaining all the little things that you do, something as simple as you may come up with this great product and think you have the greatest name in the world, but if you're not doing trademark searches and you can't get the URL, well, now you're back to the drawing board on the name. And sometimes that is one of the hardest things to come up with. Coming up with a great product is sometimes easier than coming up with the brand and the name and then protecting that brand and name going forward. So is there any advice that you would give to someone on how they would go ahead and start that process on their own?
Definitely. You want to put up the e-commerce legal guide on the screen?
Yeah, that'd be great.
Okay. Yeah, so this is really a playbook for anybody selling anything direct to consumer online. And it's written without legalese, it's written in plain English, and it covers the landscape. And in a way, it's kind of, we created something with easily 300 or 400 hours of work into it that is free, that in some ways kind of works us out of a job, because if clients really take the time to read this, they're not going to need us as much. They're going to save money in attorney's fees. They're going to save money in avoiding legal issues down the road. But it's got these sections. 1 easy way to avoid class actions, 3 things all subscription retailers must know, and so on. And one of the sections is how to add value to your brand with trademarks. So when you first conceive of a product and you think, okay, I'm not interested anymore, if you ever were, in just running an offer. I don't want to just be an affiliate. I want to create something real that I can be proud of. I want to build a brand. But for that matter, even if you're running an offer, you still need to do a trademark search. Don't get me wrong. But yeah, if you want to build a brand, especially, you better do a trademark search, because your trademark is your brand. And so what you should do.
And not just your brand, it's the identity of your company.
Exactly. The golden arches for McDonald's, the Nike swoosh, those are synonymous with those brands. And when people see that, they immediately have an association. So what you want to do with trademarks is first, on your own, do a Google search and go to the US Patent and Trademark Office website and see if that name looks like it's available. But that, to stop there, would be a huge mistake. You want to hire a trademark lawyer to do a real search, and that will look at misspellings or words that are maybe not exactly the same, but close enough to create a likelihood of confusion. And you're looking also at what categories or verticals. There's another trademark out there for another product. Is it in a similar category or vertical or an adjacent category or vertical? And so a trademark lawyer will be able to say, okay, this trademark will be low risk or medium risk or high risk. And if it's low risk, that's great. If it's medium risk, then there's sort of a business decision to be made. And if it's high risk, you probably should avoid it. There can be identical trademarks in different categories, of course. There's Peter Pan peanut butter and Peter Pan bus lines, Delta faucets and Delta airlines. So that's not the end of the analysis, but it also can be the case that the words can be spelled differently or be pronounced differently, but there could be a likelihood of confusion, because if you launch a product and you printed your labels and you created your website and you're very proud of this, but you haven't done a trademark search, you could be making a lot of money for the company that owns that trademark, because they could show up and not just send a cease and desist saying stop, in which case you might have to destroy all of your inventory and all of your advertising, but they might show up and say stop and disgorge your profits that you made since you launched this brand.
Yeah, it could be damages.
That's right. We've talked before about when you start with an idea and it's kind of like a campfire with wood, some gasoline, and a match. You're able to get something going. It keeps you warm, and then you want to build it to maybe have a campsite, and then maybe you want to have a shack, and then maybe you want to have a house, and you want to have a mansion. You want to then ultimately build a castle, right? But castles, as we know, are likely to be attacked.
Yeah.
There are barbarians at the gate, and there are dragons flying overhead. And the more successful you are, the more those things can come to be. And the brand owner or any entrepreneur needs to be aware of how they can protect themselves. And in this space, you can have competitors that are ripping your content. So you want to apply for a trademark registration after you do that trademark search, or someone else doesn't come along and steal your trademark. But there could be competitors
and copyrights. You're right.
Copyright registration too.
Copyright.
Yep, that's right. Your ad copy or your website, your web pages, or it could be your product label. It could be your VSLs. Even your website can be subject to copyright registration. And so you want to protect those. And that adds value to your business too, if you're looking to sell down the road. You see that on any episode of Shark Tank when they're talking about, do you have any protection for this intellectual property, this new idea? So you could have your competitors trying to steal from you. Then you could have class action lawyers that are really eager to make a buck and can find things that maybe didn't even occur to an advertiser, because they think they are complying with the law. They think they're doing a good job, but there are so many statutes out there with traps that most people are not aware of, except the class action lawyers are. Then, of course, there's the Federal Trade Commission and attorneys general that can bring enforcement actions. And then lastly, and this gets all overlooked a lot, you can also suffer from within if you don't have good employment agreements and non-disclosure agreements or agreements with your business partners. Sometimes those can create problems down the road. So these are all sort of threats, but with reading the e-commerce legal guide and having good counsel, you can really protect yourself from those threats and build on a strong foundation. Have the walls in place, have the moat in place, have good sight lines, so you can really protect your castle.
So going back to your metaphor, guys, as you're listening to this, we don't pour gas on the fire until we have a product that's running. Then you pour gas on, and then you grow into the castle that Damon was talking about. But let's talk about class action attorneys. They're very predatory in nature, where they look for anything. They misconstrue anything that they can. And the way that the law works, so that you're aware, it doesn't matter how in the right you think you are guilty until you can prove your innocence. And that is the way that our broken legal system works. So if someone comes up and says, oh my gosh, these guys are doing all these horrible things to these consumers, and whatever their line of allegations are, it is your job as the business owner to disprove all of those allegations in a court of law. Is that right, Damon?
Well, as a practical matter, that's basically right. The reality is that the way a case starts is the plaintiff prepares a complaint and then files that with the court. And the defendant can move to dismiss that complaint. But it's easy for a plaintiff to make up allegations and satisfy their pleading burden, even if the allegations are not accurate. And so what happens often is a motion to dismiss is denied, and then you're in the throes of discovery, which can be very expensive and requires production of documents and interrogatory responses and deposition testimony and expert testimony. Unfortunately, depending on the pace of the court, that can often drag on for a year, sometimes 2 years. And then you have an opportunity to put your evidence on a motion for summary judgment. And if that's not granted, then ultimately trial. And of course, a lot of cases settle in the meantime. There are lots of plaintiffs' lawyers making a lot of money bringing consumer class actions. And again, some of the types of issues, they can be avoided. One area where plaintiffs' counsel are bringing class actions right now has to do with subscription billing laws and businesses that haven't provided clear and conspicuous disclosure of their billing terms and provided a easy mechanism for the consumer to cancel. And that's a really serious enforcement priority for the FTC in going after the trial offer, skin, muscle, diet types of companies. So we have a section in the e-commerce legal guide about complying with subscription billing law, what you need to do there. And it's fixable. You can avoid it. Things like made in USA claims. Companies often think that if their product is actually made in the US, that they can make a made in USA claim, but the law concerns whether the ingredients or the components of the product are sourced from the US, not where it's actually put together. There have been a lot of class actions brought over discount pricing claims, where an advertiser says, here's what we typically sell the product for, but they slash through and say, today we're going to sell the product for just this low amount. Rather than $299, you can get it right now for $79, limited time. But if they haven't actually sold it for that larger price in the past 90 days, and under California, it needs to been the prevailing price, you can get sued for false discount pricing claims.
Yeah. Well, there's another one that's big right now, Damon, which is the CCPA, which is very similar to GDPR. Right. I think it's 5 or 7 states right now that require you to have opt-in consent for cookies. How do you address that? We have services that are built in, one called clym.io, CLYM.io, and it automatically puts it on the states or the countries that you're selling into to capture the consent that's required. But if you're using services other than Checkout Champ, what are you doing to capture that? Because if you don't capture that and you're in a state that requires it, you can get sued.
Let me go back to the guide here. So that's actually something we discuss at page 53. And it's hard for lawyers to keep up with how quickly the law is changing in the area of privacy. And so it's really hard for business owners. This guide was updated in February, and on the privacy section, it's due to be updated again. But this describes what you're talking about. And just in the last couple of years, we've got not just California, but Florida, New York, New Jersey, Utah, Connecticut, Colorado, Virginia,
and more to come. And trust me, when these state AGs start looking, it's their job to find people that are in violation and sue you.
That's right.
Yeah, you can see that $100 to $750 per data. So make sure that you have a solid data retention policy to keep you in compliance, such as the consent that goes on your website.
Yeah, you really need to have a real privacy policy and a documented process for how you use consumer information and how to remove information about a consumer on request. We've got a new colleague, Graham Reynolds, who just joined a few months ago, came over from Shopify. And we've got some other great people who focus on privacy law as well, but they are nonstop busy.
So let's go back to something that you'd mentioned earlier, that you're continuously learning nuances of e-com because everything's changing so fast. If you could go into what are some of the top lessons that you've learned where you're like, oh, I would have never thought of that. What is there any, I'm sure it's in the e-commerce legal guide if someone has time to go through and read the whole thing, but what are some of the nuggets that you think in the last year or so that you've learned that were aha moments for you?
There's so many different ways to answer that question. In the last 2 to 3 years, the line has really changed in terms of what is considered to be deceptive or compliant advertising, because the FTC has become much more aggressive than ever before. It's recently issued notice of penalty violations directed to the dietary supplement industry. A couple of years ago, they issued notice of penalty violations directed to the money-making opportunity industry. So that could be everyone from multi-level marketing to financial publishing to business opportunity to even like gig economy, Uber, DoorDash kind of businesses. And so what they're doing there is advertising claims that maybe 4 years ago would have raised an eyebrow at the FTC, but they wouldn't have taken action. Now they are going hard at those companies. And so what the focus is not necessarily whether a claim in advertising is true. It's got to be true, but that's not the test. It's whether, when you consider the overall net impression, is the advertising deceptive? And just to give you an example of what I mean by that. So the FTC is saying, even though this financial publisher says this product that provides trade alerts predicted that this stock was going to go through the roof, and it did, and predicted that that stock was going to go through the roof, and it did, and that's true, it's deceptive if the advertiser doesn't disclose what is typical. That if they've made 50 trade alerts over the last 6 months, what was the win rate for those trade alerts? What was the average return across all of them, both winners and losers? Or it could be a BizOp course. If you have testimonials saying, I made a ton of money taking this course, I made a ton of money taking that course, and look at me, I'm so successful. And those are the testimonials, but that's not typical. And most people who took the course, it's kind of like buying a subscription to a membership to a gym. Most people don't get fit because they buy the membership, they don't actually show up and do the work. But if that's not typical, you've got these testimonials, but that's not what the average person experienced, the FTC would say it's deceptive. Dietary supplements, same thing. Before and afters of weight loss, the FTC would say deceptive, unless you conspicuously disclose what is typical. It's a changed landscape, and it makes it hard for companies to compete when they're trying to satisfy that standard. And there are others out there that are real bad actors. And unfortunately, sometimes the FTC goes after the companies that are trying to do it right, but the FTC doesn't think they've hit that bar, and it can be very expensive.
Absolutely.
Yeah.
Well, you've 27 years practicing law, last 13 years in e-commerce law. How did you come to focus on advertising, online advertising and e-commerce law?
Yeah. So the first half of my career, I was kind of a jack of all trades litigator, and I was going to court and traveling the country and taking 2 or 3 depositions a week. And I love litigation. It's kind of, it's combat in a way. I love the strategy involved and I've got that competitive drive. It's fun. Cross-examining someone, standing up in front of a judge, being someone's advocate. It's all really fun. But at the same time, I had clients that said, hey, Damon, thank you so much for your help in this case. We can't thank you enough. We really want you to come to our holiday party, but don't take offense. We hope we don't have to talk to you for a while. And that's because litigation can be miserable. It's a grind. And I thought, okay, I now know a lot about these companies from having defended them or been a plaintiff representing them. I don't want to I've gotten to know them, like them. I want to continue to help them. So I started thinking, how can I help them outside of litigation? And there's other stuff I know. There's other stuff my colleagues know. We know how to improve their contracts now. We know how to protect their intellectual property. We know how to protect their advertising. And so I started to think, okay, I'd like my clients to think of me not as Damon as our litigator, but Damon as our lawyer for whatever it is. And just really knowing, again, the business issues. And I had some clients in San Diego back in the 2012, 2013, 2014 time period, especially. There was a lot of serious entrepreneurs that were in their late 20s doing cool things online. And they really taught me a lot, actually. I learned all about affiliate marketing and payment processing and everything relating to Google and Facebook and PayPal, you name it. I mean, just all these things. And in my old firm, Venable, we had people that were subject matter experts in different things too. So I was able to really build a team there. And then when I came over to my firm now, Gordon Rees, about 3.5 years ago, just all my clients came with me, and we've got a really strong team now. It's also more fun to represent clients, to help them grow their business rather than figure out how to win a lawsuit. You're helping create more value. And so it's more satisfying. And I still litigate, of course, but it's just a piece of what I do.
That's going to lead into my next question. As a small business owner, you think, oh my gosh, attorneys are so expensive. I would rather put that money into product or advertising or web design, whatever that might be. Is there a cost-effective way for a small business to really ensure that they're protected?
Absolutely. This is going to sound repetitive, but it start with reading the e-commerce legal guide. I just want to make sure people understand how user-friendly it is. Each section of the guide, it starts off with a little story, kind of a day in the life of someone selling something online. And so it's relatable. I had a client who posted on Facebook in this direct response marketers group on a Saturday afternoon. He had his laptop open and a glass of bourbon on the rocks sitting by the pool. And he just said, I'm finally reading what Damon told me to read a year ago. And oh my gosh, I wish I'd read this when I started off. I would have saved so much money and probably made a lot more money. So for someone starting off or for someone more experienced, I strongly encourage you to read it. One thing occurs to me, we've talked about this before, Matt. Checkout Champ has really creative minded, brilliant clients. I know the personality type, and you're attracted to what's fun for you. And the other stuff is not so exciting. And so you kind of ignore it. But if you really want to be at the top of your game, if you think about professional athletes, whether it's Steph Curry or Tom Brady, you name it, they are really good at running fast or jumping high or hitting hard in their sport. They've got those talents for sure. But one thing they also understand are the rules of the game. And if you don't take the time to learn about subscription billing compliance or advertising law, to know if you're approaching a line or if you've crossed the line, to know about trademarks and copyrights, know about how to have a strong agreement with your business partners or with your service providers. If you don't take the time to learn those rules, you're not going to make it into the big leagues or the Hall of Fame. You're going to get by on your strengths, but you're not going to be fully formed.
And that's the kind of work that your team does for your clients, right?
That's exactly right.
Are there any particular clients that your firm, your team serves?
Really anything and everything under the sun that's being sold to consumers. So we have a lot of clients selling supplements. We have a lot of clients in telehealth. We have quite a number of financial publisher clients and other digital products, whether it's business courses, clothing, gadgets, food, of course, beverages.
Yeah. Food, beverage. Let's talk about the VSL, because that's becoming, it was big and then it kind of went away. Now it's becoming big again. I see these copywriters time and time again, Damon, and they get so focused on, oh my gosh, this pitch is fantastic. This is going to sell me tens of millions or hundreds of millions of dollars. But when you're done with that VSL, you definitely want to send it over to a firm like Damon's to review it, to make sure that you're not going to get in trouble with the FTC or the attorney generals. It is very important that you have someone review everything, because they're going to look at it through a different looking glass than you will, because you're the excited marketer who's ready to pitch your product. They're looking at it as, how do I protect this person's ass from getting sued?
Yeah, that's exactly right. We spend a lot of time, probably once every 2 weeks or so, with our new clients doing like a 1-hour copywriter training session and just talking about guardrails and ways to pitch the product that are going to be fun, evocative, exciting, lead to high conversions, but aren't going to take unnecessary risk. And that can help so that when we get that VSL, we don't have to do a real heavy markup. A lot of times it's, what are the backups? What's the substantiation behind these claims? And sometimes it's dialing it back a little bit. One of the things we also talk about is wanting to talk with the client about a kind of a risk spectrum, because with advertising claims, it can be nuanced and sometimes on a spectrum of absolutely incredibly deceptive to aggressive to very compliant. And if you think of it in terms of a scale of 10 to 1, if 10 were as if the FTC were Olympics judges and they said, this is a 10, this is 100% compliant, we have no concerns whatsoever. But on the other hand, a 1 could lead you to go to jail. We sometimes see clients and they say, okay, how is our copy right now? And we might say it's a 5. And they say, okay, can you get me to an 8 or a 9? They're concerned about going to a 10 because they're afraid they won't be able to compete. But one of the things I like too is that when we're doing VSL copy review, we're not just attacking it like a lawyer, but we're thinking creatively, and we know what the advertiser wants to communicate. And with changing a statement slightly, we can have substantiation. If it's a claim about the future, it may not be able to be substantiated because it hasn't happened yet, but we can take that claim and rewrite it to refer to the past in a way that can be substantiated. And we can use what's called puffery rather than talking about an objectively measurable criteria when we're describing our product. We can use puffery to create an exaggerated claim that isn't measurable and still gets the consumer excited, but it's not something that can be sort of proven true or false because it's kind of an embellishment.
So Damon, let's talk again about the e-commerce legal guide.
Yeah.
I want to hear about what went into it, what it covers, why did you prepare it, and how it can help advertisers, because people don't like to read in general because they're busy, but they will sit and listen to a podcast or an interview. Let's go through just the table of contents and what you think some of the most important sections would be for someone to read.
Well, this is kind of an opening letter from me. I was never into Dungeons and Dragons as a kid and still haven't watched Game of Thrones. But the more we help clients, the more I think about castles and the more I think about risk. And this is kind of describing the analogy before that if you're trying to build a castle, you want to make sure you have protection.
Yep.
And there are barbarians at the gate who will be looking to attack. And so, again, what we do with clients is we want to help them make money, but also sleep well at night. And we worry about our clients so they don't have to worry. So what we have here are the different sections. One easy way to avoid class actions. And this discussion is about how to make sure that in your checkout page, the consumer agrees to website terms of use. And then inside your website terms of use to have a provision that waives any class action and also requires mandatory arbitration for any claims. 3 things all subscription retailers must know. This is talking about ROSCA and the state subscription billing laws. Companies that are not complying with these laws are extremely vulnerable. They can get sued by class action.
It stands for
the Restore Online Shoppers Confidence Act.
Yep. There's a lot that's into that. And I was actually reading the first version of ROSCA, I think back in the early or mid 2000s when it first came out. They take it very seriously.
They do. How to add value to your brand with trademarks. How to protect your ad copy with copyrights. Trademarks and copyrights are different. Sometimes there can be an overlap, but copyrights are basically an original creative work. So typically people think of it as books or songs, artwork, but it could also be your product label or your ad copy.
Or it could be software code.
Yep, that's right. And there's a whole interesting issue right now with AI, of course, in copyrights. I won't go down that rabbit hole, but it's going to be interesting to see how that plays out. How to create engaging and compliant advertising. We don't want to just create compliant advertising. We want to create advertising that's still going to help sell the product. The basics all dietary supplement and cosmetic retailers must know. That it addresses things like avoiding drug and disease claims and what kind of claims you can make with respect to structure, function of the human body, and certain ways to revise claims to make them compliant. The basics all business coaches and financial publishers must know. So this gets to money-making opportunity offers and earnings claims and the importance of disclosing what is typical. How to make green going green. That's kind of a cheesy title, but it's talking about any kind of product that's talking about environmentally friendly or eco-friendly, recyclable, all natural. There's a real emphasis now on going after companies that are accused of greenwashing, where they're trying to claim that they are helping the environment. The laws there are pretty stringent, especially in California.
Well, and I see more and more companies come up talking about sustainability.
Exactly.
Right.
Even words like non-toxic can be a problem. Non-toxic for the environment or non-toxic if ingested. We need to be precise when we're making those kinds of claims. Again, something that most people don't necessarily think about, but it can be a trap that can cause you to get sued and have to spend a lot of money. The keys to successful influencer marketing, the keys to successful text and telemarketing, that's dealing with the Telephone Consumer Protection Act. The keys to successful email marketing. There are state statutes that address email, like California Code 17529, and what needs to be identified in the body of the email, in the footer, unsubscribe links. These are areas where plaintiffs' lawyers are making a lot of money. And of course, with influencer marketing, we talk about how to have a strong agreement with your influencer and some of the issues with the FTC endorsement testimonial guidelines. How to protect your tech and confidential info with agreements. Business owners often hire independent contractors, and they ask the independent contractors to create technology for them or to create copy for them, even build their website. But oftentimes they don't have the right agreements in place to make sure they actually own what's been purchased. Confidential information of businesses' trade secrets. You've built something really innovative, and if someone walks out the door and goes to your competitor, you want to be able to stop that. What you need to know about privacy policies, an area of law that's rapidly changing and is tremendously important. Avoiding website accessibility suits. This is another hotbed for plaintiffs' lawyers. There are people who are visually impaired, hearing impaired, and are frustrated that they can't purchase products and then sue. And I understand.
Well, let's talk about that for a second, because you talk about visually impaired. If you actually have a website, if someone is light sensitive or they're colorblind to certain colors, it covers all of this, and you could be at risk because of that particular law.
Yeah, and it's well intentioned, and visually impaired, hearing impaired people should be able to access websites. At the same time, some of these plaintiffs aren't really trying to buy anything or visit that website. It's just a way for plaintiffs' lawyers and the plaintiff to make a lot of extra money.
Predatory.
It can be, yeah. And so we discussed what you need to do to comply there. It's really working closely with your website developer and sometimes an outside consultant. There are also widgets or plugins that can help make your website more accessible, that integrate with the consumer's technology. It used to be the law that only brick and mortar businesses were considered places of public accommodation that were subject to the Americans with Disabilities Act, but there's case law over the last several years that says websites are also, like brick and mortar locations, are places of public accommodation. What you need to know about state sales tax, another area that sort of come to the forefront since the decision from the US Supreme Court about 4 or 5 years ago, that businesses that are selling online have to pay state sales tax if there's a state statute requiring it. And these state statutes typically have thresholds for the amount of revenue derived from consumers in a particular state. And once you hit that threshold, the business is construed to have an economic nexus with the state. And so companies like TaxJar and Avalara have had tremendous business helping retailers calculate, collect, and remit state sales tax. And businesses that aren't complying with these requirements could one day get a large bill from a state saying this is what you owe. It can also be a real impediment if you're trying to sell your company and you haven't satisfied your state sales tax obligations. The benefits of business insurance. This is huge. Anybody selling anything or having any business for that matter really should have business insurance. And so we discussed the different types of insurance coverage that you should have. It could be advertising claims insurance, could be products liability insurance. It's hard to get insurance for certain types of claims. The premiums can be very high, but you should definitely consult with an insurance broker and explore what your options are there. One area we don't really cover here, but it's sort of embedded in a lot of these topics, is just the importance of treating the customer right and having really strong customer support. The number one thing that leads to regulatory action or consumer class action is going to be customer complaints. If there's customer support personnel, making sure they're trained for all different scenarios and how to make the customer feel satisfied, not just save the sale and make money off in the short run, but how do we help promote this company's goodwill and reputation online?
Accessibility. It's not just an 800 number. They want to be able to SMS. They want to be able to text you. They want to be able to email you. Maybe they don't want to talk to anybody. They want accessibility to be able to either cancel a subscription, request a refund, or say, hey, where the heck is my product? Or my product arrived damaged. How do I get something? How do I get this replaced? Make it accessible. There's a lot of great customer service companies that we can refer out to you also, but they're being accessible to your customers is going to help you win the hearts and minds of the future consumers. Because what does that become? That becomes a testimonial.
That's right.
Right.
That's right.
It becomes a review, a 4 or 5 star review that will help the next person who's interested in your product. Oh my gosh, I had an issue with my product. They picked up on the first call. They answered my email right away. They gave me a refund and resent the next product. I mean, that is a testimonial that's going to help you sell the next product.
Yeah. Any business owner should have a really close finger on the pulse, ear to the ground, or just be embedded with their customer support staff, even if it's outsourced. And to even mystery shop and call in as a disgruntled customer and to see how the call is handled. We do that for our clients, pose and as customers, and just see how they react. And then we sometimes audit recordings and get feedback on how this call could have been handled differently.
Yep.
And of course, compensating customer support people based on not just metrics of money, but of ratings and reviews is tremendously important. You got to make sure there's a real incentive to treat the customer right at all times.
Absolutely. All right. Well, Damon, I don't want to take up a ton of your time. I know that I told you it was going to take 20 minutes here. We've been on for nearly an hour, about 40 some odd minutes.
Yeah.
So let me say this in closing. Number one, I appreciate you not only as my attorney, but as a person. Anytime I call you, I'm like, hey, what do you think about this? You want to just sit there and spitball for a few minutes. And I feel like you really give a shit about what I do and really care about keeping me out of trouble. And so I appreciate that, number one. Number two, Damon and his team are fantastic. And so what I'm going to do for you is at the end of this video, I'm going to drop the link to the legal guide below. And how do you want these people to communicate with you, Damon? If they want to ask for a consultation?
Just send me an email. My phone number is actually on the guide too. You can call or text me.
Yep. Phone number, email will be on the legal guide. Feel free to reach out to Damon and his team and they'd be happy to help you. Damon, any closing statements? I think we covered a lot.
No, we didn't talk about music or politics or hunting, but we can talk about that some other time.
Yeah. Wonderful.
All right.
Well, good. Everyone, Damon Wright from Gordon Rees. And again, I'll be dropping the link below. Damon, thanks for your time and we'll talk to you soon, buddy.
Thanks, Matt. Take care.